Um, I know I am not the normal chair of this committee, but our chairperson is delayed, so I'll be starting the meeting on his behalf, and then when he arrives, I will turn it over to him. So with that, welcome to the October 11th, 2024 California Board of Behavioral Sciences Policy and Advocacy Committee meeting. My name is Wendy Strack, Vice Chair of the board. Before we convene, I'd like to remind everyone present that the board is a consumer protection agency charged with administering and enforcing the board's laws. Where protection of the public is inconsistent with other interests sought to be promoted, the protection of the public shall be paramount. Committee members will be participating remotely from private, non-public sites. The public may participate remotely or in person at DCA headquarters at 1625 North Market Boulevard, Suite S 102. I will announce when we're accepting public comment on the various issues, and the meeting moderator will open the lines as appropriate. Each commenter will have 3 minutes to comment. Moderator, would you please provide the audience with instructions on how they may participate during the meeting at appropriate times?
Sure, this is the moderator. When public comment is requested, I will open up the question and answer feature on WebEx. You may also choose to raise your hand by clicking the hand icon next to your name on WebEx. Once again, you'll be given 3 minutes to speak and a 15-second warning. And at the end of your time, your microphone will be muted and we'll move on to the next person. If you're an audio-only participant, you can raise your hand by pressing *3 on your device. And I believe that's the end of my instructions.
Great, thank you. I would now like to call the meeting to order and ask Christina to call roll to establish a quorum.
Good morning. John Sovek,
Present, LMFT member.
Abigail Ortega,
Present, LCSW member.
Wendy Strack.
Present, public member.
We have a quorum.
Thank you. Board staff, would you please introduce yourself?
Good morning, Steve Sodergren, the Executive Officer of the Board.
Sabina Knight, Legal Counsel for the Board. Roseanne Helms, Legislative Manager for the Board.
Christy Berger, Regulatory Manager for the Board. Sarita Risso, Special Projects and Research Analyst for the Board.
And good morning, Marlon McManus, Assistant Executive Officer for the Board.
Great, thank you. Now is the time for the public to introduce themselves if they would like. It's completely voluntary. Moderator, is there anyone let's say in the room, is there anyone in the audience that would like to introduce themselves first?
Good morning, Shanti Ezrin, California Association of Marriage and Family Therapists. And I'll pull up a chair.
All right, this is the moderator. I do have one person on WebEx who'd like to introduce themselves. Selena Leo Raphael. I'll request to unmute your microphone. Click the unmute me button when the prompt appears on your device.
Raphael, Senior Behavioral Health Policy Advocate for the California Alliance of Child and Family Services. Thank you so much.
All right, this is moderated with a couple more people, so I'll go in order received. Next, I have Ben Caldwell. And once again, you'll click that unmute me button when the prompt appears on your device. Oh, Ben, if you were speaking, I don't think we heard. I saw your microphone on, but we didn't hear any audio.
Okay, I'll try again. Can you hear me now?
Yes, we can hear you now.
Okay, thank you. Sorry about that. Good morning, Ben Caldwell, MFT.
All right, next we have Kathy Atkins. Apologies, Kathy. I think similar thing happened. We didn't hear your audio, but your microphone was unmuted. Let me try clicking unmute again.
Hi, this is Kathy Atkins from CAFT. Good morning.
Good morning. We could hear you. Thank you. All right, and we have Olivia Kiner.
Associate Professional Clinical Counselor.
All right, and that's looks like everyone. Oh, I apologize. We got one more. Stephanie Gabler. Request to unmute. And Stephanie, you'll want to. Oh, there we go.
Thank you so much.
All right, and that looks like that was everyone. So this at this point, would you like me to close the Q&A panel?
Yes, thank you. Okay, I believe we are skipping item 3 this morning, so we will move on to item 4, discussion and possible recommendation regarding proposed amendments to the Business and Professions Code regarding supervision for professional clinical counselor trainees, regarding W-2 forms for supervised experience claimed, regarding unprofessional conduct provisions for telehealth, and regarding degree program certification of meeting licensure requirements. So Roseanne, will you provide us with an overview?
Yes, thanks, Wendy. So each year, staff takes a look at our statutes to see if anything that's technical or minor needs to be clarified or cleaned up in the statutes. And then usually those items either go in an omnibus bill that the legislature runs every year, or if it's that time of year, which it is this year, then a sunset bill, which runs every 4 years. So we looked at some and approved some amendments for inclusion in either the omnibus or the sunset bill at the September 2024 meeting. But staff has identified some additional smaller amendments that the board may wish to also consider including. So I'm going to go, there's 4 of them. I'm going to go through them one by one and then open it up for discussion. So the first proposed change is shown in attachment A. And basically, there is a section of the LPCC statute that discusses the amount of supervision required for professional clinical counselor trainees. And it says that no more than 6 hours of supervision, whether individual, triadic, or group, shall be credited during any single week. For PCC trainees, they're not like MFT trainees in that they don't get to count pre-degree or in degree supervised experience. They only can count post-degree experience for LPCCs. So that sentence is sort of misleading in that it implies that PCC trainees can count supervised experience while they're in school. So we're recommending that that sentence for PCC trainees be struck. It was probably just amended in there because it was there for MFT trainees, and it's not necessary. Also, just wanted to note that the section being amended 499.46.2 is a double section right now due to some sunset date in that provision. So both sections need to be amended to preserve the changes being made to law if we move forward with that change. So that's the first item. The second item has to do with amending LMFT, LCSW, and LPCC law regarding W-2 forms for supervised experience claimed. And these 3 sections for each of those 3 license types require individuals applying for licensure to provide the board with copies of their W-2 tax forms for each year of experience claimed upon application for a licensure. We run into a situation that sometimes when somebody's applying, the associate might not have a W-2 tax form for the experience gained in that current year for which they're applying for a licensure. W-2 just may not have been issued yet. So, and if that happens, the board requests a copy of the most recent pay stub for that year. So we're proposing adding language in statute to sort of memorialize this and clarify this, that it would basically be, these sections would be amended to stay if the W-2 is not available for experience gained during the recent tax year that has not ended yet, then the associate needs to provide the board with a copy of the most recent pay stub. So that's the second change. The third proposed change has to do with the board's unprofessional conduct provisions for each license type. Each of the 4 practice acts has a unprofessional conduct provision, making it unprofessional conduct to violate Business and Professions Code section 2290.5. 2290.5 is the section of law that outlines the requirements for the provision of healthcare services via telehealth. However, each unprofessional conduct section uses slightly different language right now to state that violating Business and Professions Code 2290.5 is unprofessional conduct. So I've included what each one says. We think that the LPCC statute is the best example of what the law should say. It says basically failing to comply with procedures set forth in section 2290.5 when delivering health care via telehealth is unprofessional conduct. So we believe that all 4 sections should use the same language. So we're suggesting that all 4 sections look like the LPCC statute currently that's cited in the packet. Excuse me. And then finally, the 4th amendment has to do with amending Business and Professions Code section 4980.38 for LMFTs. And that is degree program certification from the degree program that the degree meets registration and licensure requirements. And there's a little bit of it's a simple change, but there's a little bit of a complicated history behind it. Both Business and Professions Code section 4980.36 and 4980.37 contain degree requirements for AMFT registration and LMFT licensure, depending on the date that the degree was begun and completed. Business and Professions Code 4980.36 contains the current degree requirements. 4980.37 is for older degrees that were begun and finished past a certain date in the past. And applicants with older degrees qualifying under 4980.37 must also complete additional coursework described in Business and Professions Code section 4980.41 before sitting for the licensing exams. 2 courses required in 4980.41 are alcoholism and other chemical substance dependency and spousal and partner abuse assessment detection and intervention. For those 2 courses prior to 2014, they must have been completed within the required master's degree program. If they were not before that time, they could not be remediated and the degree was considered non-qualifying. And so a definite unintended consequence of this was that some applicants did not have this coursework in their qualifying degree and were unable to qualify for licensure unless they obtained a new degree. So in 2013, the board ran a bill to address this issue and concern, and it allowed those 2 courses to be remediated outside of the degree program by taking either an additional master's level course or continuing education. However, we've noted that Business and Professions Code section 4980.38, which requires degree programs to certify their degree meets the requirements for licensure, still mistakenly requires schools with degrees that qualified under 4980.37 to certify that the 2 above discussed courses, the spousal and partner abuse and the alcohol and chemical substance dependency, are contained in the qualifying degree, and that's erroneous. It does not have to be contained in it. So we are proposing to strike the references in 4980.38B2 that a qualifying degree must certify it meets the requirements in 4980.41 A4 and 5, which is the alcoholism and chemical substance and the spousal and partner abuse, as those 2 courses are now permitted to be remediated and have been since 2014. So those are the 4 technical changes, and I will open it up for discussion.
Thank you, Roseanne. I don't have any questions. I think it seems pretty straightforward to me, but I will look to my colleagues if you have any questions or comments. Seeing none. Would someone like to make a motion?
Do you want me to read the motion?
Please. Yes,
Okay,
you-
the motion would be to direct staff to make any discussed changes, which it sounds like there are none, and any non-substantive changes and bring to the board for consideration as a legislative proposal.
Wonderful.
I so move. This is John Sovek, LMFT.
Great. Do we have a second? I will go ahead and make this. Oh, sorry. Go ahead, Abigail.
Sorry, I forgot to raise my hand. I'll make a second.
Thank you. Let's see. I think we're on to public comment. Are there any comments from folks in the room?
Yes, there are.
Hello? Okay. Good morning, Shanti Ezrin with CAMT. No concerns with any of the proposed amendments. Also appreciate the clarification around the W-2 form requirement and supporting our associates. So with that, just wanted to thank staff for their work on these items.
Thank you. Seeing no other comments in the room, moderator, will you open up public comment online, please?
This is a moderator, and at the direction of the committee, I've opened up the Q&A feature for public comment. Members of the public, if you would like to make a comment on this item, you can either use the Q&A icon down at the bottom right-hand corner of your WebEx screen, or use the raise hand function. And if you're an audio-only participant, you can raise your hand by pressing *3 on your device. All right, and it looks like we do have a request from Selena Leo Raphael. And Selena, you'll be given 3 minutes to speak and a 15-second warning. Please click the unmute me button when the prompt appears on your device.
Thank you, Selena from the California Alliance of Child and Family Services. Also agree with Shanti. Thank you. We are in agreement and have no concerns about the 4 proposed amendments. And also thank you for the clarification and opportunity to provide the pay stubs in lieu of the W-2. Thank you.
All right, this is the moderator. Appears there are no further requests for public comment. Would you like me to close that Q&A panel?
Yes, thank you. Okay, with that, Christina, please take the vote.
Abigail Ortega,
Yes.
John Sovek,
Yes.
Wendy Strack,
Yes,
motion carries.
thank you. Next on the agenda is discussion and item 5, discussion and possible recommendation regarding licensing requirements for the 90-day rule. And Steve, we'll turn it over to you.
Thank you. So I think this item, we're really looking more as a discussion. Maybe there'll be some possible recommendations, but there was a concern over people that, over applicants that are within the 90-day rule. We don't really have necessarily any oversight over them. Plus, we don't know who's actually practicing out there during this period. So that's kind of the basis of this conversation. That was the concern. Just to go through kind of an explanation, the current law requires an applicant to have an associate registration with the board to accumulate post-degree hours with certain exceptions. A registrant or applicant can count supervised hours gained before they receive their registration if they apply within 90 days of obtaining their degree and their workplace completes a live scan fingerprint before they begin accruing hours. And this is what's commonly known as the 90-day rule. There is an exception. You could actually, if you're in an exempt setting, you could still practice without even the 90-day rule being into effect, but you wouldn't be able to collect hours if we didn't have that 90-day rule in that exempt setting. So it does allow, the 90-day rule does allow applicants to, if they're not actually, let me make another caveat. you cannot, the 90-day rule does not apply to private practice. So the 90-day rule does allow an applicant to start gaining those supervised hours after their graduation. And I think that might have been one of the nexus for this rule that was put into place quite a few years ago. We did have a period where there was long delays and people that were graduating were having to wait quite a few months to be able to collect hours. So I think that was part of the reasoning behind the 90-day rule. The plus is you could start gaining your hours for your supervised hours during this period while we're reviewing your application or your application is in play. The downside is we really don't know as a board, who is actually practicing and performing services out there. And again, it doesn't allow us to have that oversight because the individual is not licensed with us. So in 2013, we kind of brought this issue up again that we were looking at, is it really good to have this 90-day rule? And during that period, what we were looking at is they asked the staff to do an actual study to see if a one-year study to track people within this 90-day period to review if there's any, I guess, significant abuse or really concern on the enforcement side. One of the concerns brought up during that period is that if you have somebody who applies for licensure and they have a criminal background and we have to do a review, they could actually be practicing until we actually either deny their application or we actually approve their application. And that in those cases could be longer than a year. Additionally, without the enforcement part, applicants who apply within the 90-day rule can still, if they have deficiencies in their application, practice during that time until either their application is expired or we approve it. So could be a long period of time before they actually get registered. Going back to that study, there wasn't really any major concerns brought up in that study about the enforcement process or concerns about, I guess at that time they were looking at consumer protection. They didn't really see anything at that point. Again, the 90-day rule was brought up in 2018 under AB 93, and that I believe was actually looking at doing away with the 90-day rule. The professional associations, as you can see the letters that are attached to this memo, the professional associations were really not advocating for that AB 93. And so we came up with a solution for that, and that was we could still keep the 90-day rule, but individuals who are applying under the 90-day rule would have to have a live scan fingerprint done by their agency that they're working with prior to performing services. And that was kind of the mediation between that. And that's currently what's in play right now. And additionally, in 2018, we did extend the 90-day rule to licensed clinical social workers. Part of the 90-day rule, like I was saying, it allows a registrant to actually collect hours right out of the gate if they satisfy all the rules. It does help with continuity of care. So you do have individuals that are working in agencies, and if they didn't have the 90-day rule, they would have to maybe stall their practice with those individuals. Like I said before, the downside of the 90-day rule for us, we really have no jurisdiction over these individuals who are actually practicing in the field. And then we don't have an idea of who is practicing. So there is benefits for us to know that too. Where we're at right now, I think we really just wanted to bring it up again to see maybe there's some solutions, like to get some feedback from stakeholders. I think where we, as I put in the memo, we can maybe look at, I mean, is there appetite for doing away with the 90-day rule? I'm not sure, so we want to open that up. Then again, another alternative is maybe we could register trainees. And that was something that was actually in the 90s. Thank you, Christy, for pointing that out. In the 90s, we did start registering trainees so that the trainee is the person going through their practicum during their school time. So that is a possibility, maybe looking at that. So really just kind of bringing this subject out again, just to hear what thoughts are on that and seeing if anybody would be interested or if they thought that maybe registering trainees might be something that could be useful to us and could possibly replace the 90-day rule. And Wendy, that's it.
Great, thank you. First, I will look to my committee members to see if there are any initial questions. Abigail, and then John.
I was curious, so there were no major concerns from the study. I'm so glad that we had this study, right? So that we can learn from it. But there were no major concerns. And so I'm wondering, I guess, what is still the concern, right? If there were no concerns from the study. And then if there are applicants applications that have deficiencies, like what percentage of the applications have those issues? And are they issues that are like easily dealt with, right? That push those applications forward? That was my first question. And then my second one is if like registering trainees, if it's something that's being considered, will that slow down the registration process for the associates? It's because it's already taking time, right, and manpower to register the associates to where we need a 90-day rule. So we're adding more, another process, further delay that. So I don't know if that would help or hurt, right, that process. And then I was also curious about how come private practices are exempt from the 90-day rule, as far as people being able to gain hours while they're in those spaces. So.
Okay, I was trying to write those down. Let me see if I can. Let me see if I can hit all the points here. So, first of all, yeah, there was no concern back in 2018. I think really the concern that we're talking about, and it's always been kind of that the underlying concern is that we don't have oversight over these individuals during that time. And once again, we have no idea who is practicing out there. So it's just kind of free range. As for the amount of percentages for applications being deficient, I believe in the registration applications, we have usually about a 20% deficiency in those applications, but most of those deficiencies are easy to fix. To fix. I'm trying to think of the right word, but we'll just go with fix. So usually they don't have either their transcript in or you don't have your form Bs or certain forms that you need to actually get that completed. Like I said before, though, some deficiencies may take longer if you are in an enforcement. If we have to review your application, it could take longer. But once again, if you look at that stats, most individuals will end up receiving their license, and if not, though we receive their license, we rarely deny those license or registrations. As for the private practice, I think that kind of goes into, and see if you can maybe hopefully I state this right. I think way back when there was not a concern, but kind of a thought that exempt settings, which are government agencies, schools, and such, had a really solid kind of hierarchy of individuals that would be able to supervise and oversee individuals in a better manner than possibly a private practice could. And so I think there was a lot of, I don't know, I think when you see those private practice versus the exempt setting, I think that was kind of the concern, making sure that these individuals had proper supervision. And within the government agencies, there's a certain structure that has to exist. Within private practice, it's not there. Whether that's legitimate or not, I'm not speaking towards that. But that, I think, was kind of the thought to that. Perfect. I got a thumbs up. Right on. Okay, so that's to that. And now for the question about will this create further delays? Actually, I see benefits. I hope there's nobody from the registration unit or licensing unit watching now, but I see benefits from this because it could, I'm seeing we could actually morph this in, or not morph, but implement something like this where instead of you having that the 90-day rule, if you were registering as a trainee, we might be able to look at your schools, know that you're coming down the line through a school, and understanding what you're actually seeing if you actually would meet the requirements if you graduated from that school, and kind of really expedite the process. I'm thinking there's a way we can implement that. It would be something implementation-wise, it would be pretty robust implementation, but I think it's something that we could do and could actually benefit the whole process. I hope that I spoke to all your questions.
Yeah, no, absolutely. That's what yeah, I got what I got from this. Yeah,
Okay.
but
Great, thank you. John, you have some questions?
Abigail, thank you for asking all of my questions. But Steve, when you're talking, two more thoughts came up. And maybe this is also Steve and Roseanne question. So if the consideration was to start registering trainees again, does that have to go through statute and regulation? And so that would be a longer term process, or does the structure exist to implement it more quickly? And then second of all, with trainees, would that registration include, or it's the consideration, it would be a full fee for the behavioral sciences registration packet, or could we consider that for trainees, especially just coming out of school, financial burden, that there could be a second tier for trainee cost of registration?
Yeah, it would definitely have to be statute.
Yes.
And I'm assuming there would probably be some regulations that we'd have to implement with that.
Sure.
And in my mind, this would be something that if we went forward with that, it would be something, a very minimal process. That means including, fees and paperwork, and making it what I would be concerned with, and what I would want us to, if we did move forward on an idea like that, is to make it the least burdensome on a trainee. So I'm envisioning it would be nothing as robust as the registration application. So.
Although one thing, Steve, to speak to this idea, all the work you're doing to streamline the application process, get a lot of it online, and this could initially begin the beginning of an ongoing file that travels with you as you go through the process of becoming a fully licensed person. What I actually might make it easier to catch small mistakes early on. It might actually help the registration staff to be more efficient in this work. I mean, I see there's some pluses that could go with it.
Yeah, and that's one thing I didn't really mention too. We did it back in the 90s. It turned out it was, I believe, too much of a workload. But honestly, with Breeze and the ability we have now, it could be a simple, logging into Breeze, giving us your name and your school, and there you go. So it could be a simple process. Could be.
Okay. We received word that our illustrious chair has logged in at this point.
We could go to in-house questions, I guess.
Okay. Is there any questions in the room? And then after that, Chris, I will turn the meeting over to you.
Oh, sorry, there is. Yeah. Public comment. Yeah.
Hello again, Shanti Ezrin with CAMPT. Absolutely appreciate the discussion on this topic today, and certainly we acknowledge the concerns raised about oversight. However, like one of the attachments in the materials, we wouldn't support a removal of the 90-day rule for many of the reasons that I'll kind of just quickly go over here. One of the reasons a removal of the rule would have significant negative impacts on continuity of care and supporting our workforce across all licensure types. As mentioned, delays in processing applications can occur, and that would lead to a long wait time and losing out on clinical hours that those associates or those postgraduates would otherwise have gained working in exempt settings between graduation and the time that their registration is approved. And additionally, I'll also add that DHCS, the Department of Healthcare Services, this year has provided their policy statement and an informational notice that allows Medi-Cal behavioral health delivery systems to utilize postgraduate candidates who submitted their application for associate registration under the 90-day rule to provide services to Medi-Cal beneficiaries. So a removal of this rule would undo actually much of the department's work to align its policies with the BBS and support this part of the workforce under the Medi-Cal system. So CAMPT, we are open to ideas to work around the concerns around oversight that were raised today, and we're more than happy to engage with staff to further solve any problems for both the consumer protection angle and then also ensuring continuity of care. Thank you.
And we have more public comment in here.
This morning, I apologize, but I'm Sarah with William Jessup University, and we also, I'm sorry. I'm Sarah Krasko with William Jessup University, and we have the graduate program, MACP graduate program. We also support the 90-day rule. It gives our students an opportunity to continue at their sites. With the majority of our students they form really strong bonds with their clients, and so they want to continue on and have that continuity of care. But I also, because I work closely with them and with their processes and procedures, I like the registration or registering them early, getting them in the pipeline early so that they continue and it can be streamlined and they're able to continue to see the same clients. And the question I had is, since this has been done in the past, what is the process for registering them? I know we spoke that it was minimal, but is it just a form that they would submit, or what would that look like?
That I can't really speak to what we did in the past. Envisioning the future, it would be because there's not much they could give us. They couldn't give us transcripts. They couldn't give us, I guess they could supervisor, but that would be something that if this is something we wanted to move forward with, that's where the work would begin to try to figure out. But like I said, I think with the guys that, at least in my opinion, should be as least burdensome as we can make it. So.
Thank you.
And that's it for in-house.
Okay.
All right. This is the moderator, and at the direction of the committee, I've opened up the Q&A feature for public comment. Members of the public, if you would like to make a comment on this item, please click the Q&A icon located at the bottom right-hand corner of your WebEx screen or use the raise hand function. And audio-only participants may raise their hand by pressing *3 on their device. All right, and it looks like we have a couple requests. I'm going to go in order received. First, I have Selena Raphael, and Selena, you'll be given 3 minutes to speak and a 15-second warning. Please click the unmute me button when the prompt appears on your device.
Thank you, Selena Lou Raphael, again with the California Alliance of Child and Family Services. Agree very much with the comments already. Thank you for your work on this. Our concern as well would be, we have worked very hard with DHCS on ensuring that there are options for associates and clinical trainees in a lot of the work as we're trying to meet the goals of CalAIM and the workforce struggles that many of our nonprofit providers are offering to children, youth, and families in this state. There are a lot of concerns around the workforce, and we want to make sure that there is continuity of care for clients as well and eliminate these barriers to licensure. So we would very much not want to remove the 90-day rule. I read all of the attachments that you included in the materials. Thank you very much. And it does look like there hasn't been any concerns over these years with any claims or concerns from people who've received services. So we did want to highlight that. So there has been no unintended harm from this 90-day rule in the past. So really wanted to emphasize that. We are open to the idea of requiring students to register and having some process for them to get in the pipeline, because we do think maybe even accruing hours and having oversight and some support through their process through graduation and after might actually help the workforce scenario. So happy to discuss that further. Thank you so much.
All right, this is the moderator, our next individual, Kathy Atkins. Kathy, you'll be given 3 minutes to speak and a 15-second warning. Please click the unmute me button when the prompt appears on your device.
Hi, this is Kathy Atkins from CAFT. I wouldn't say I have anything overly additional to add to what those who have already testified have said. I just am testifying to underscore, I think, the importance of this conversation and ensuring we don't do anything that harms provider and or patient for the reasons many have articulated. So sort of as Selena just mentioned, we are more than happy to engage in a conversation and discussion if there is issues or concerns of how best to handle them, especially 30 years after trainees were registered. If that's the direction the BBS is going, I suspect with the breeze and everything mentioned, this would be an easier process if that's the direction desired. So similar testimony, and also I can't see who's on the attendees, and I certainly don't want to speak for NSAW or CalPIC, but I suspect they would want to weigh in on this conversation as well if it moved in a direction. And so we look forward to engaging if that's the direction the committee or board goes. Thanks.
All right, next I have Ben Caldwell, and Ben, you'll be given 3 minutes to speak and a 15-second warning. Please click the unmute me button when the prompt appears on your device.
Thank you. Good morning. Ben Caldwell, MFT. I appreciate the discussion of this issue. In line with Ms. Ortega's comments, I'm not clear on exactly what problem is trying to be solved here. It sounds like your own study suggested there are no significant concerns with the system as it exists now, the 90-day rule as it exists now. And it does seem to strike a good balance between the, of course, necessary public protection elements, but also enabling people to get out into the workforce and provide services, having already had that live scan that helps ensure public protection for people gathering hours under the 90-day rule. I also used to teach full-time for one of the graduate programs leading to licensure in California. I still teach as an adjunct now. And from my academic experience, I suspect that universities would have pretty significant concerns with the notion of registering trainees if there is any possibility that that process would create hiccups or roadblocks. as it likely would for at least some folks. If there's the possibility of delays in application processing, if there's the possibility of an application as a trainee being considered somehow deficient, that's going to start to impact universities' timeliness of degree completion, and that gets into accreditation status and all of that other kind of stuff. So those may all be solvable problems and answerable questions, but I would think that we would want a significant amount of input from universities along the way if you were to move in the direction of registering trainees. Thank you.
All right, this is the moderator. Next I have call-in user 2. And call-in user, I'll request to unmute your microphone. You're going to press *6 to unmute yourself. You'll be given 3 minutes to speak and a 15-second warning.
Hi, good morning. This is Nick Boyd, LPCC. I'm calling in and I just wanted to support some of the comments that were made. I understand the concerns certainly raised about slowing down timelines to potentially getting the registrations, those types of things. And certainly there's been no known reports of issues from the consumers. However, I would respectfully disagree that there's no issues with the board not having oversight of those practicing in the field and delivering mental health services to our consumers in the state. I think it seems very counterintuitive to suggest that the board has no oversight of those that are effectively practicing without a license, without a registration, without any known status as not a concern. So I would actually encourage that be further considered. Additionally, Steve's recommendation and suggestion about registering trainees, I think, is particularly important as well, as it falls in the similar vein of the comment I just previously made about not knowing the number or the status of trainees practicing in the field. Ben raised, I think, certainly some important considerations, although I think it's, again, about understanding who are the folks delivering care to our consumers. As it exists today, that is unknown. There are over 50 universities in the state, hundreds, potentially thousands of those practicing in our state from just California institutions, an unknown number of out of state. And I would be really pushing the board in this particular committee to really consider what the impact of that is, given that we don't know. There's no mechanism to bring up issues when things arise in terms of consumer protection. There's not very clear requirements for supervision. There's not clear requirements in terms of coursework that has to be completed before fieldwork. So there's a lot of real thought that needs to go into this process that we need to be mindful of. The board's and this committee's purpose is certainly consumer protection first and foremost, certainly workforce development, but how do we really ensure that we are giving our consumers the best opportunity to receive the best possible care, knowing that the board thoroughly following and tracking and giving them a mechanism
15
to
seconds.
report. Thank you.
All right, this is the moderator. Next I have Chiaki Nomoto. And Chiaki, you'll be given 3 minutes to speak and a 15-second warning. Please click the unmute me button when the prompt appears on your device. All right, and you are unmuted. Looks like you muted yourself. Let me request to unmute one more time. This is the moderator, Chiaki. It appears we cannot hear you. I do see that you wrote a comment in the Q&A. If you'd like, I can read that out loud. Also, you can try connecting your audio through your phone instead by going up to audio and video on WebEx, clicking switch audio, and then following the call-in prompts. But to read Chiaki's comment in the Q&A, during the 90-day period, are they considered trainee or associate? We, County Behavioral Health Department, have not been utilized 90-day rule due to credentialing complications for Medi-Cal billing. I support training registration system.
Yeah, they're considered an applicant for licensure. They're not a trainee. A trainee is defined as someone who is still in their master's program. An associate is somebody who actually has a registration number with the board.
All right, and then this is the moderator. I also have a comment from Natasha Wright. Natasha, you'll be given 3 minutes to speak and a 15-second warning. Please click the unmute me button when the prompt appears on your device.
Hello, can you hear me?
Yes, we can hear you.
Oh, great. I just wanted to say briefly that I'd urge this committee to consider the impact on recent graduates in terms of their ability to obtain employment, especially if they've been offered employment at the site where they've done training. The 90-day rule currently it provides a way for new graduates to continue working. And I think if that rule is repealed, then there should be some other system because there can be long delays in getting the associate number and it can impact people's ability to obtain and maintain employment. That's it.
All right, this is the moderator. Appears there are no further requests for public comment. Would you like me to close that Q&A panel?
Motion?
I have a comment regarding some. I'm hearing some concern about the 90-day rule and deleting it. I don't think that we're proposing here to straight up just delete the 90-day rule. That's already sort of been litigated. I think that the thought sort of is, what if we put in some place sort of a system in place to register trainees so that the 90-day rule is no longer needed. In other words, they would have that continuity as they move over from a student to a graduate to an associate. And so that, I think that's kind of what we're getting at here is we're exploring, is that possible? And what would that look like? And what are some of the pitfalls? I mean, we don't want the delays. It would have to be something pretty simple. There would have to be a process for somebody, like, I think it would mostly affect social workers, what hadn't decided whether they were going to board licensure or not. But what would some sort of a process where it was more streamlined from graduation to associate, and then there wouldn't be any kind of weird in between, like somebody brought up that you're not really a trainee and you're not really an associate. Like what would something like that look like, and how could we implement it? So I wanted to kind of clarify that point.
Yeah, and I think for the recommendation, I know because it does a possible recommendation, and I think I would say maybe the recommendation from this conversation is to have staff look more into possibly a registration, for trainees, and we can provide more information and maybe start that discussion at future committee meetings. That's what I would suggest. Back to you, Wendy or Chris. I don't know.
I think Chris is taking over.
You're up.
All right. So do we need to make a recommendation then for staff to investigate further what that would look like to vote on?
Sure. Yeah, that'd be great.
Okay. So then is it a vote or just a direction?
recommendation. So it's just I don't know. Yeah, we don't need. You could just, okay, we're not going anywhere with it. So just that we don't have to take a vote.
All right,
So-
then, yeah, please do further
Okay.
investigation. It's clear that this is an important issue to continue looking at.
Perfect. Thank you.
All right, so next up on our agenda is item number 6, which is, sorry, my glasses aren't working. Update on board sponsored and board monitored legislation. Roseanne, would you please provide us with the overview?
Yes, the deadline for the governor to sign bills on his desk or veto bills on his desk was September 30th. So we now have answers on all the legislation that the board was tracking. Happy to report that both bills that the board was sponsoring or sponsoring part of were signed by the governor. That's SB 1024. And that bill actually proposes clarifying two of the board's statutory requirements, the requirements to physically display a license and registration and the allowable number of supervisees per supervisor. And that bill is going into effect on January 1st of this coming year. And there is some action that will need to be taken on part of licensees and registrants regarding these. They need to be knowledgeable of it. So we have prepared 2 FAQs for our website and our social media, and those will be appearing on our website sometime within the next few days. And a listserv will be going out. We're going to distribute the information to our professional associations. So we're kind of in the looking to get the word out phase of implementing that bill now. The board's omnibus bill that we sponsored a piece of SB 1526 that was also signed by the governor. That's just a minor technical change. Everything else is pretty much reported in the packet. There's a couple of things that happened after this went to print. SB 26, which would have created a scholarship to implement the CARE Act, was actually vetoed by the governor due to, he cited budget issues in his veto message and existing HCI programs already in place. SB 1067 was also vetoed by the governor. That was a bill that would require certain healing arts DCA licensing boards to expedite the license process to give priority status for a licensee who intends to practice in certain medically underserved areas. That bill was vetoed. The governor cited concern about the aggregate effect of expediting licensing programs. And then finally, AB 2270 and AB 2581 were both signed by the governor. Those bills require the board to consider including a CE course in menopausal mental or physical health and in maternal mental health in its continuing education requirements. So look to that to be a future board agenda item in the future. And that is it.
All right, thank you, Roseanne. Any comments or questions from our board? Any comments or questions from our participants in the room?
No. Or is that, no? Nope, none here.
Nope. All right, moderator, are there any comments from our remote participants?
This is the moderator, and at the direction of the committee, I've opened up the Q&A feature for public comment. Members of the public, if you'd like to make a comment on this item, please click the Q&A icon, locate the bottom right-hand corner of your WebEx screen, or use the raise hand function. And it looks like I do have a request from Elise Springer. And Elise, you'll be given 3 minutes to speak and a 15-second warning. Please click the unmute me button when the prompt appears on your device.
Elise Springer from the California chapter of Postpartum Support International. Just in regards to AB 2581, I wanted to bring an additional bill to the board's attention. AB 1936, which was a maternal mental health screening bill. This builds on a prior maternal mental health screening bill, 2193, that required screening during pregnancy. This new bill that the governor just signed, 1936, now requires mental health screening for all pregnant folks in the first, during pregnancy and before 6 weeks postpartum, with the intent to really bolster referrals for mental health systems. So I just wanted to make sure the board was aware that there's more legislation
designed to really ensure that folks are getting the maternal mental health care and the perinatal mental health care that they need. The problem being, of course, that our BBS licensees do not have training. So just know that there's more screening coming and more legislation. Again, that bill was 1936, and I wanted to flag that in relation to 2581. Thank you.
Thank you.
All right, this is the moderator. Appears there's no further requests. Would you like me to close that Q&A panel?
Yes, thank you, moderator. All right. Next on the agenda is item number 7, update on the board rulemaking proposals. Christy, would you please provide us with the overview?
Yes, thank you. The disciplinary guidelines regulation proposal that would result in updates to the board's uniform standards related to substance abuse and disciplinary guidelines. That proposal was approved by the board in August of 2023, and additional changes were approved by the board at its September 2024 meeting. And the proposal, along with all of the required documents that go along with it, have been submitted to the Department of Consumer Affairs, Office of Legal Affairs to begin the initial review process. So that's kind of just the starting point once the board approves the language. The next regulation package would result in updates to the board's unprofessional conduct regulations. It would strike regulations that duplicate statute and would provide for transparency by adding requirements related to the Confidentiality and Medical Information Act. And actually, I'm updating the status as to what was in the memo. This has actually been approved by the Office of Administrative Law as of 2 days ago. Yay. And so we'll get that uploaded to our website soon. It will take effect January 1st of 2025. The next regulation package is the telehealth regulations approved by the board in March of 2024. That package has been submitted to DCA Legal Affairs for the initial review process. The board approved 2 new regulation packages at its meeting in September of 2024. One is on continuing education and one is on advertising. So I'm working on preparing all the documents to get those submitted for initial review as well. It will take some time as there's a lot of background work to be done before it starts initial review, but we're working on that right now. And that's all I had.
All right, thank you, Christy. Any comments from our committee members? No. Any comments from our participants in the room?
None in-house.
All right. Any comments from our remote participants, moderator?
This is a moderator and at the direction of the committee, I've opened up the Q&A feature for public comment. Members of the public, if you would like to make a comment on this item, please click the Q&A icon located at the bottom right-hand corner of your WebEx screen or use the raise hand function. All right, and seeing no requests, would you like me to close that Q&A panel?
Yes, thank you, moderator. And next on our agenda is item number 8, which are suggestions for future agenda items. Do any of the committee members have additional agenda items for future board meetings? No, I can't see Wendy. No, it doesn't look like it. Okay. How about from our participants in the room?
Doesn't look like it here either. Nope.
All right, moderator, would you please open the lines for our remote participants?
All right, this is the moderator, direction committee. I've opened up the Q&A feature for public comment. Members of the public on WebEx, if you'd like to make a suggestion for a future agenda item, either click the Q&A icon down at the bottom right-hand corner of your WebEx screen or use the raise hand function. All right, seeing no requests, would you like me to close that Q&A panel?
Yes, thank you, moderator. And next on the agenda is item number 9, public comment for items that are not on the agenda. As a reminder, the board may not discuss or take action on any matter raised during this public comment section, except to decide whether to place the matter on the agenda of a future meeting. Do any of our committee members have comments for items that are not on the agenda? Nope. How about from our participants in the room?
None here.
All right. Moderator, how about any comments from our remote participants?
This is the moderator, and at the direction of the committee, I've opened up the Q&A feature for public comment. Members of the public, if you'd like to make a comment for items not on the agenda, please click the Q&A icon located at the bottom right-hand corner of your WebEx screen, or use the raise hand function. All right, and it looks like a request from Kathy Atkins. Kathy, you'll be given 3 minutes to speak and a 15-second warning. Please click the unmute me button when the prompt appears on your device.
Hi, this is Kathy Atkins from CAMT. I just wanted to make a quick public comment thanking Steve and Christy and Roseanne for all the work they're doing, and to note in front of the stakeholders and the committee. I know part of their charge is to do public outreach and stakeholder outreach, and I don't think that the average person recognizes how much time and energy they're putting towards reaching out to the associations and various stakeholders to help our various groups understand sort of some of the strategic priorities and reasons for various decisions. So I just wanted to make a note, because usually it's people complaining about various things. So I just wanted to publicly thank them. And while we don't always agree, lots of the conversations and communications make it so that we can focus on the areas of disagreement and quickly get through the areas of agreement. So anyways, thank you. That was it.
Thank you, Kathy.
All right, this is the moderator. Appears there are no further requests. Would you like me to close that Q&A panel?
Yes, thank you, moderator. And next on our agenda is item number 10, adjournment. Thank you so much for your participation in today's meeting. As a reminder, our next board meeting will be on November 14th and 15th up in Sacramento. We hope to see you all there. Thanks so much and have a great weekend.